Okay, we're starting off with a court proceeding, and this is a change of plea proceeding, and we're going to be talking about a Harvey waiver. Okay, so a Harvey waiver is something which allows the court to consider dismissed charges in a criminal case. Okay, so obviously the circumstances revolving around that would have to be qualified or whatever. But typically, charges that have been dismissed would not be able to be taken under consideration in a future case. So the Harvey waiver does away with that. Okay, so we have Plaintiff Counsel, Mr. Ford, and I am Mr. Ford.
I am the defendant.
I am the court.
I am the
Defense Attorney, Mr.
Maceo.
Mr.
Maceo. Yeah, so
Okay.
this truly is a defendant, not a witness, so I like to do that and try and encourage you to hit defendant. It's all colloquy, no Q&A. What's the GBI stand for? In a criminal case, what do you think it is? Well, I'm not going to tell you. You have to listen and try and figure it out in context, okay? If one of you online knows and you want to chat it to me, go ahead. Okay. We are ready to begin, and this is not counted, so we can go really fast, we can go up and down and all around, okay? I would rather have it be more up and down than, you know, just all too slow. So, here we go.
It's the court for the record. Walter Templin.
Present, Your Honor.
Mr. Templin is present before the court in custody. We have discussed this matter. I think we reached a resolution.
Okay.
On file ending 746A, Mr. Templin will be entering, if acceptable, a plea of no contest to 245A4. For that plea, he will be admitting to the low term double because of the prior strike, which he will be admitting. He will also be admitting the GBI enhancement for an additional 3 years for a total of 7 years with the new strike. No probation, subject to parole, subject to the ominous weapons ban, would be required to stay away from the victim, restitution if any, all remaining to be dismissed and or discharged in light of the plea. Public defender is requesting to waive the felony fee, and we are also requesting a probation report.
Okay, there's a 484 Harvey waiver.
There are 2 trailing misdemeanors that are dismissed with the Harvey waivers.
The other one is 647F.
Right.
So we will add Save Mart as a restitution on the prison commitment, and those cases stand dismissed.
Thank you.
Is this what you are prepared to do, Mr. Templin?
Pardon me?
Is this what you're prepared to do?
Yes, Your Honor. I am asking the court, if I may, postpone sentencing for a little while.
I am going to put sentencing to over so we can get that probation report. So at a minimum, we will put it over 4 or 5 weeks.
That's fine, Your Honor.
Motion to withdraw the previous entered plea of not guilty.
So moved.
Court allows it. It is going to be a plea to count 1 for the low term, 2 years. That will be doubled for the strike admissions for a total of 4 that will run consecutive with the GBI. 3 more years for a total of 7 that will be served in state prison. Do you understand?
Total of 7
Total of 7
with 80%
at half.
half-time?
Sorry, at 80%.
I thought it was 85.
Does the GBI make it a serious or violent?
This is a new strike, but he has a prior strike. It is my understanding he has to do it at 85%.
The question is, though, on the new case, is it an 85% case?
Because of the GBI, I believe so.
We will take the 80.
If I'm going to properly advise him, I need to figure it out. If it was the 211, for example, it would be 85%, not 80.
I was under the impression it was 85, but I'm more than happy to stand to be corrected.
It is only the GBI that makes it the strike based on the charge.
Right.
Under 12022.7A of the Penal Code, it doesn't say anything about 85%.
I would assume.
I would presume it would typically be at 50%, but since admitting the strike, it will be served at 80%. So your pre-sentence credits would then be 50% and then 80%. Do you understand?
80%, Your Honor?
It is going to be 80%. Do you understand?
Yes, Your Honor.
Once you finish serving that time on this charge, you will then be placed on parole or post-release community supervision for up to 3 years if there are any parole or pre-RCS violations. You would receive additional 180-day terms. Do you understand?
Yes, Your Honor.
The restitution fine in this matter is between $300 and $10,000. There's also a parole or PCRS for revocation restitution fee that is stayed pending possible revocation in one of those programs. Do you understand?
Yes, Your Honor.
You may be required to pay restitution. You have a right to a hearing. Do you understand?
Yes.
If you are not a citizen of the United States, a plea of guilty or finding of guilt will result in your deportation or in a refusal of naturalization, citizenship, amnesty, or reentry into the United States. Do you understand?
Yes.
Your plea constitutes a conviction of a serious or violent felony, which is also known as a strike. This means in the future, if you are convicted of any felony, the term of that conviction will automatically be doubled. And if you are convicted of 2 or more serious or violent felonies, and then convicted of a 3rd serious or violent felony, the term of that conviction will be a minimum of 25 years to life. Do you understand?
Yes, Your Honor.
If you enter a plea today, you are waiving your right to a preliminary hearing. Do you understand that right?
Yes, Your Honor.
Do you give up that right?
Yes, Your Honor.
You are waiving your right to a speedy or public trial by judge or jury. Do you understand that right?
Yes, Your Honor.
Do you give up that right?
Yes, Your Honor.
You are waiving your right to confront and cross-examine all witnesses who testify against you. Do you understand that right?
Yes, Your Honor.
Do you give up that right?
Yes, Your Honor.
You are waiving your right to present a defense, which means you have a right to testify, present evidence on your own behalf, and have free subpoena issued to get your witnesses to come to court. Do you understand that right?
Yes, Your Honor.
Do you give up that right?
Yes, Your Honor.
You will be also waiving your right against self-incrimination, which means that no one can force you to testify against yourself. No one can force you to enter a plea of guilty against your will. Do you understand that right?
Yes, Your Honor.
Do you give up that right?
Yes, Your Honor.
Any questions about your rights?
No.
And have you had enough time to discuss the case with your lawyer?
Yeah.
Concur in the waiver?
I do.
Have any promises or threats been made to obtain your plea?
No, Your Honor.
Are you under the influence of anything?
No, Your Honor.
You are charged in count 1 with assault with force, likely to produce great bodily injury, a felony, Penal Code 254A4 on February 1st, 2015. To this charge, what is your plea?
No contest, Your Honor.
The same effect as a guilty plea in here. Do you understand?
Yes, Your Honor.
In connection with that, it is alleged that you inflicted great bodily injury, that is Penal Code 12022.7A enhancement. Do you admit or deny?
Admit, Your Honor.
Actually, the enhancement, it says it makes it a serious felony, not a violent felony, so it would be 80%. Also, in connection with that count, it is alleged that you suffered a prior serious felony conviction, 42491. That is Penal Code 1170.12B, 667D enhancement. Do you admit or deny that prior felony?
Admit.
Factual basis?
February 1st of this year, about 2100 hours, defendant went to his mother's house in Lathrop in violation of a restraining order. He began to punch the victim, his brother Joseph. Once on the ground, the defendant began to kick the victim all over his body, face, and head. This was witnessed by his mother. If called to testify today, his brother Joseph will testify that he suffered a broken pelvis, which resulted in this attack. The defendant admitted going to the house in spite of the restraining order. He does have the strike as alleged in the complaint.
Concur?
Yes.
The court finds a factual basis for the plea. The court finds the defendant knowingly, intelligently, and voluntarily waived his constitutional rights and entered the plea and finds the defendant guilty.
Oh, I shouldn't have said it. GBI? Great bodily injury. Thank you. Okay, this next transcript has a lot of weapons terminology in it, not technology. take one, pass it down. We've done this as a take in the past, but it's kind of tough. So I thought we're just going to do this as a drill. So I would like to start out in, you follow along and mark your copies. We're going to start off in 14s. We'll start at 210. And when we get to page 5, down towards the bottom, the last question, that timing mark at the 5-minute mark, let's go to down to 15s. Page 5, minute 5, down to 15s. And then when we get to page 12, at the 12-minute mark, let's go back up to 14s. Okay, so this is going to actually be 17 minutes. We don't do that in this class too often, go straight through. So I am plaintiff attorney. Oh, I was going to look at the preview word too and see if there's anything on here that might be helpful for you. Wairika. The rest of these I'm just going to have you hit out. I am Mr. Plummer for the attorney.
Go ahead.
I am the witness.
I am the court.
I am the attorney for defense, Mr. Al Ford.
I don't think I said plaintiff attorney. You know what, court and defendant, can you move your placards toward the middle of it? Thank you. Here we go. Question by Mr. Plummer, starting in 14s. I would like to direct your attention to what appears to be page 7 of your evidence list, and that's page 284 of the Discovery Materials Council, and specifically to item G1.
Yes, sir.
I may have been mistaken in my notes, but would you tell me again what G1 is, please?
It's a bullet jacket recovered from Wairika Police Unit 250 in the right rocker panel.
But a bullet jacket is not the same as a bullet cartridge?
No, sir. The cartridge would be an unexpended round.
Or the casing?
A casing would be different than a bullet jacket too. Yes, sir.
Okay, now directing your attention to page 2 of the report that you prepared on October 11, and that would be page 297 for council.
It's October 11.
I think it's your October 11th report. No, I'm sorry. The first sheet that I was looking at said October 11, but that appears to be related to a different matter. This would be the, I think it is a portion of, yeah, it's a portion of the report. The final page is page 3, and that's signed October 23.
I believe I said there was a high degree of concordance and the likelihood exists that it was fired by that weapon. Yes, sir.
Is there anything whatsoever inconsistent with the slug that was taken from Officer Carey's body that is inconsistent with the Winchester Western Super X 22 Magnum hollow point cartridges, which are present in the box marked 21 in evidence, and the type of bullet that would be found in the box marked 2B?
No, sir.
You testified to discovering certain materials in the board marked, does that have any evidentiary number in this proceeding?
I don't think we marked it.
The board that has been referred to as board 20, you said that you found material which was consistent with that of a 357 bullet. Is that correct?
Well, the jacketing material is specifically consistent with a 357 and in particular the weapon of Officer Carey. And the lead fragment was just consistent with bullet material. I can't really make a determination as to the possible caliber.
You were able to determine from the examination of the jacketing material that there were consistencies in the land and groove pattern as with the weapon identified to you as belonging to Officer Carey. Is that correct?
Yes, sir.
Other than the material found in the board, which we have been referring to as board 20, did you ever examine any other fragmentary material that is inconsistent with the 22 Magnum? Let me rephrase that. I will withdraw and rephrase it. You testified that you observed numerous items of fragments and bullet fragments and jacketing material in connection with the Wairika Police Department Unit 250. Is that correct?
Yes, sir.
Did you find anything in those fragments which would exclude or eliminate the possibility of there having been fired from a 22 Magnum?
No, sir.
Did you find anything in any other bullet fragments which you have examined which would exclude their being fired from a 22 Magnum rifle?
Only those fragments removed from board 20.
Can you make any determination from the fragments removed from board 20 whether or not the 357 material was fired directly into the board material?
The fact that the bullet was fragmented and the fact that it did not penetrate the board would not be consistent consistent with the bullet leaving a weapon and then striking that board.
Would that be consistent with it ricocheting off of some other object?
Excuse me, I'm sorry. Could I have that last answer repeated, Your Honor?
Yes, you can have the last question and answer.
Thank you.
Do I infer then that it would be consistent with the bullet striking another object and ricocheting into the board?
Yes, sir.
Considering the art of bullet comparison and identification to firearms, is it correct that once a match is made and identity is determined, that excludes all other weapons of a similar nature?
Yes, sir.
I have no further questions.
Mr. Alford?
I just have a few questions, Your Honor. Mr. Sasser, you have in front of you item 39 and 3H and 4H.
I don't believe so.
I think they were brought up.
May I have these marked as defendants next in order?
Do you want two separate items?
Yes, Your Honor.
They will be R and S if my alphabet is correct.
And the third item, Your Honor?
It will be T.
I show you an item which has been marked Defendant's Exhibit R for identification. Could you examine the contents of the package and tell me what it is, please?
Do you want me to open the package?
If you wish to satisfy yourself as to its contents.
I'd rather not. On the envelope itself, it says 22 Magnum cartridge case. Then it says Super X.
Which one are we talking about?
Item 39, which is,
Defendants R for identification, I believe.
R. All right. That's a 22 caliber?
R.
All right.
And that is the casing that you identified as making a positive match as having been fired from item W1. Is that correct?
Yes, sir.
And I'll show you Defendant's S for identification. Would you examine that and tell me what that is?
Incidentally, Your Honor, Mr. Sasser declined to open the envelope. I would like to do so and let the record reflect that I am doing so and examining the contents of the envelope.
Very good.
Item 4H is an envelope, or I'm sorry, exhibit number S is an envelope that should contain a 22 Magnum cartridge casing.
And that is one of the 22 Magnum cartridge casings that you found to be consistent with having been fired from item W1, but not positively fired. Is that correct?
Yes, sir.
Then I'll show you Defendant's T for identification and ask you to tell me if that is what it is.
I'm looking at that. May the record reflect that I have restapled Defendant's Exhibit R.
It may so reflect.
T is a manila envelope, which should also contain a 22 Magnum cartridge casing.
And is that the one that we've been referring to as 3H in previous testimony?
Yes, sir, it is.
And that is also a 22 Magnum cartridge casing, which you identified as being consistent with having been fired from W1, but not conclusively. Is that correct?
Yes, sir.
Similarly, Your Honor, may the record reflect that I am opening the exhibits for the purpose of examination and I have just cut the clerk's tag off.
All right.
Mr. Sasser, I would like to show you a page which was apparently Xeroxed from your notes yesterday on that page, I placed a red circle around an item identified as T. Could you examine that first and tell me if that appears to be an exact copy, a Xerox copy of your notes?
It appears to be.
Remington Nylon 77 serial number 2193646, I believe. Is that an item of evidence that you yourself located at the crime scene?
I don't believe so.
Did you at some time come into possession of that item?
Yes, sir.
Could you tell me when you came into possession of it?
It was received from Officer Garner on July 18, 2008.
And at what location did you come into possession of it?
Your Honor, before we pursue this line of questioning, are we not again far afield from the previous examination?
That was my last question on that item, Your Honor.
I withdraw the objection.
Okay.
And may the record also reflect, Your Honor, that I have resealed the previous two exhibits that I opened.
S and T have been resealed.
I don't seem to find any notes on that. As my recollection serves, I believe I got it from the sheriff's office.
And you took that into your possession?
Yes, sir.
And it has remained in your possession up until this time?
Up until August 30, 2008.
You testified in response to someone's questioning that you received clothing from Mr. Patrick Adams, which you subsequently placed in the freezer. Is that correct?
Yes, sir.
Did you obtain any blood samples from his clothing?
I did not subsample the clothing, no, sir.
And those items of clothing are now in court, is that right?
Yes, sir.
Your Honor, may I have Mr. Alford's last question? Looks like I lost the last words.
Yes, you may.
It is my understanding from your testimony that you are presently unable to describe the markings on, I believe now it's defendants R, items 39, which you found to be identical. That allowed you to say that it came from weapon number 1.
Yeah, I cannot recollect the specific markings and their arrangement. No, sir, I cannot.
Could you do that by examining the item at this time, or would you need additional equipment?
I would need additional equipment.
Now, in your process of seeking to obtain a match, is it correct that you first attempted to do so with 3 hollow point test fires?
Yes, sir.
And then at some later time you attempted to do so with 3 bullets of a different type?
Yes, sir.
And what do we call that different type?
Well, they were fully jacketed as opposed,
Fully jacketed?
yes, sir, as opposed to hollow points.
And did you make 3 test firings of fully jacketed rounds?
Yes, sir.
And of those 3, you were able to make a match with respect to 1. Is that correct?
Yes, sir.
And you make a match with respect to 1?
No, sir.
Your Honor, may I have a moment?
Yes.
I'm either totally miscomprehending your testimony or my questions aren't clear. You made some test firings,
Yes, sir.
and you were able to achieve a match with the test fire.
Yes, sir.
When did that occur?
That occurred after I had made all 6 test fires, but the match that I made was with one of the first of the 3 rounds that I fired, which were all hollow points that I test fired.
What was there to preclude you from making this match earlier?
I was unable to find sufficient individualizing detail to make a match. It might have been the lighting, it might have been that I just, never really got to the first area to make that match.
Did somebody tell you to try a little harder?
Certainly not.
Was there anything different about the conditions under which you made the match?
Your Honor, Mr. Alford examined this witness for over an hour yesterday on his ability to make the match. And by his tone, by the tone of the questioning, it seems like we're going back over the same ground rather than recross, redirect, and whatever.
True. I do think we're going back over grounds that we went over rather extensively yesterday.
But Your Honor, at the time, I didn't have the benefit of Mr. Sasser's note.
My specific objection is that it's beyond the scope of the redirect examination.
I don't think it is. Mr. Plummer on redirect asked about any other people in the laboratory taking a look at things, and that's what this is all about. And yesterday he testified that's what happened in the 2.5-week period. What we're cross-examining on, Your Honor, is his redirect, I think.
I've been doing a lot of reading on that particular subject, and the more I read, the more confusing it gets. But it appears from the latest cases on the subject that counsel can inquire rather at length on discovery. And there are some cases that say that counsel can't take depositions of the prosecution's witness, but it's error to preclude them from examining at considerable length at a preliminary hearing. But where we come to the fine line of where the deposition starts and discovery begins, I am not really clear at this point.
Well, the court certainly has the power to control the proceedings, and when the
Oh, I know.
when the proceeding is starting over in the same tone and the same vein as what we had previously gone into at great length, I think that the court can take the observation that we are not proceeding to an end, but are simply restarting the same material.
We've gone over that one quite a bit, yes. Now, what was the question again, Mr. Alford? I'll ask you rather than the reporter because there's been a lot of colloquy and
It was to the effect of any change in conditions of the examination between the first attempt to match the hollow points with the later attempts to match the hollow points.
that particular question has never been asked, so I'll let him answer it if he knows.
Thank you, sir.
Well, I had to set the bullets up again for comparison, so I would imagine the conditions were not exactly the same as they were before.
Insofar as you were able to observe, was there any difference in the testing conditions?
Well, they are quite similar, but as I say, the angle of the lighting might have been different. There are any number of things, but before that I was able to find a high degree of concordance, but not enough, in my opinion, to constitute a positive match. It wasn't until I continued to work with the bullets that I was finally able to find 2 areas that I felt demonstrated sufficient individualizing characteristics for a positive identification.
Now, by 2 areas, are you referring to areas entirely within the photographs that we were shown yesterday, or is that one area of the 2?
That is one area of the 2.
Is the second area photographed?
Yes, sir.
Once again, Your Honor, Mr. Alford has made great efforts to direct the court to have Mr. Sasser provide a copy of that photograph of the second area. And now we're back to the second photograph.
I'm just asking what the second photograph.
Asked and answered and beyond the scope.
That one I thought, maybe I misunderstood, but it was my understanding that this was both the photographs were of the same area. I'm glad to learn that I'm learning something different now than what I had anticipated. That one is all right.
And the last area of questioning I had, I was interested in the condition of the weapon when you first obtained it. And I am not able to put my hands on the notes immediately, but as I recall, you indicated that the slide was in place, but it was not locked. Do you recall those circumstances?
Yeah, I believe that's correct.
Okay, now is the slide the container, the cylindrical container for the weapon prior to, as they feed into the chamber, is that what the slide is in this weapon?
No, sir, it's not. By slide, what I meant to indicate is that it's a tubular magazine.
Yeah, okay.
The slide is the metal part that slips into that tubular magazine that has a follower and a spring.
Yeah, okay. We're thinking of the same thing. Now that when placed into the weapon to lock it, it must be turned. Is that what occurs?
Yes, sir.
Now, if it were not locked, the weapon would be able to fire with respect to a round in the chamber, would it not?
Yes, sir.
But would it perform its functions on feeding another round as in you go through the extraction ejection process
This weapon did, yes, sir.
with the slide being open?
With it not being,
Excuse me, with the slide being unlocked?
yes, sir.
Also referring to your own notes, at the top of one page, there is a phrase, "no excuse left." Are you able to tell me the meaning of that phrase?
These are not my notes. These are Jim Conrad's notes, and I can explain it to you if you'd like.
Would you please?
I had been bugging him about getting his notes into some kind of a report form, and once he did that, he indicated that there was no excuse left for me now to not get out my field investigation report.
Okay, that's all the questions I have, Your Honor.
Mr. Plummer?
You mentioned in response to one of the questions about the defendant's clothing being here in court, do you know actually if the defendant's clothing is here in the courtroom at the present time?
No, sir, I really don't. What I do is I turn it over to the sheriff's office, and I did that yesterday. It was my impression that it had come up here, and I really couldn't say for sure that it's still here.
It's part of the material that you brought with you up yesterday?
Yes, it is.
So if it's not here in the courtroom, it's presumably in the custody of the sheriff?
Yes, sir.
There's been some reference to the swabs that were received from the Oregon State Police and forwarded to you by the ATF. What is the ATF?
That's Alcohol, Tobacco, and Firearms. It's a federal agency located in San Francisco.
Is that the agency that does the testing for this particular type swab?
Yes, sir. They do gunshot. One of the things that they do and one of the services they offer is gunshot residue analysis.
And do you know what the results of the gunshot residue analysis was?
I've read the reports and I cannot interpret them. I'm not too sure what those reports mean.
Thank you. Nothing further.
Anything further?
I have nothing further.
All right. May Mr. Sasser be excused with the usual admonition?
No objection, Your Honor.
Yes, Your Honor.
Your Honor, if I might, I would move that defendants R, S, and T be received into evidence.
All right, they will be received. Mr. Sasser, you are not released from your subpoena, however. You can be called back on at least a 24-hour notice. Hopefully, if it's necessary to come back. All right, let's take a recess at this time. All right, we are back in session. Let the record show that parties and counsel are all present. The case is with the people. You may proceed, Mr. Plummer.
Thank you, Your Honor. The people called Charles Craig.
You will be seated, Mr. Craig, please, and state your name and spell your last name.
Charles Eugene Craig, C-R-A-I-G.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Mr. Craig, what is your occupation?
I'm a police officer, sergeant with the Wairika Police Department.
And how long have you been employed in that capacity?
Over 6 years.
Were you employed in that capacity on the 16th and 17th of July, 1988?
Yes, I was.
Were you on duty? Did you begin duty on the 16th of July on that date?
Yes, I did.
All right, directing your attention to sometime around midnight or shortly thereafter, did you find yourself in the vicinity of the Sports and Spirits liquor store in the city of Wairika?
Yes, I did.
Did anything occur at that time which attracted your attention?
Yes, I saw John Thurman run to the 76 station.
Did you recognize John Thurman at the time that you saw him?
Yes, I did.
How did you recognize him?
I've seen him before as a clerk at Sports and Spirits.
You indicated you saw him running.
Yes, I did.
What did you do when you made that observation?
Well, I pulled in the 76 station to see what was going on into that area of the parking lot.
Did Mr. Thurman do anything that attracted your attention at that time?
He yelled to some of the people at the Sports and Spirits to call the cops.
Okay, turn back. We're going to go back. This ending is not so difficult. Once we get out of the gun evidence. Let's go to page 12. We're going to repeat the last 5 minutes and 14s. Maybe not a whole 5 minutes, but sort of. Okay, so we can start at the top of the page, and that's Mr. Alford.
And what are we reading in?
14s.
Okay.
So this will be all at 210.
It's Mr. Alford for the record. Now, by two areas, are you referring to areas entirely within the photographs that we were shown yesterday? Or is that one area of the two?
That is one area of the two.
Is the second area photographed?
Yes, sir.
Once again, Your Honor, Mr. Alford has made great efforts to direct the court to have Mr. Sasser provide a copy of that photograph of the second area. And now we're back to the second photograph.
I'm just asking what the second photograph.
Asked and answered and beyond the scope.
That one I thought, maybe I misunderstood, but it was my understanding that this was that both photographs were of the same area. I'm glad to learn that I'm I'm learning something different now than when I had anticipated. That one is all right.
And the last area of questioning I had, I was interested in the condition of the weapon when you first obtained it. And I am not able to put my hands on the notes immediately, but as I recall, you indicated that the slide was in place, but it was not locked. Do you recall those circumstances?
Yeah, I believe that's correct.
Okay, now is the slide the container, the cylindrical container for the weapon prior to, as they feed into the chamber, is that what the slide is in this weapon?
No, sir, it's not. By slide, what I meant to indicate is that it's a tubular magazine.
Yeah, okay.
The slide is the metal part that slips into that tubular magazine that has a follower and a spring.
Yeah, okay, we're thinking of the same thing. Now that, when placed into the weapon, to lock it, it must be turned. Is that what occurs?
Yes, sir.
Now, if it were not locked, the weapon would be able to fire with respect to a round in the chamber, would it not?
Yes, sir.
But it would perform its function of feeding another round in as you go through the extraction ejection process,
This weapon did, yes, sir.
with the slide being open,
With it not being,
with the slide being unlocked.
yes, sir.
Also referring to your own notes, at the top of one page, there is a phrase, "no excuse left." Are you able to tell me the meaning of that phrase?
These are not my notes. These are Jim Conrad's notes, and I can explain it to you if you like.
Would you please?
I had been bugging him about getting his notes into some kind of a report form, and once he did that, he indicated that there was no excuse left for me now to not get out my field investigation report.
Okay, that's all the questions I have, Your Honor.
Mr. Plummer?
You mentioned in response to one of the questions about the defendant's clothing being here in court. Do you know actually if the defendant's clothing is here in the courtroom at the present time?
No, sir, I really don't. What I do is I turn it over to the sheriff's office, and I did that yesterday. It was my impression that it had come up here, and I really couldn't say for sure that it's still here.
It's part of the material that you brought up with you yesterday.
Yes, it is.
So if it's not here in the courtroom, it's presumably in the custody of the sheriff.
Yes, sir.
There's been some reference to the swabs that were received from the Oregon State Police and forwarded by you to the ATF. What is the ATF?
That's alcohol, tobacco, and firearms. It's a federal agency located in San Francisco.
Is that the agency that does the testing for this particular type swab?
Yes, sir, they do gunshot. One of the things that they do and one of the services they offer is gunshot residue analysis.
And do you know what the results of the gunshot residue analysis test was?
I've read the reports and I cannot interpret them. I'm not too sure what those reports mean.
Thank you. Nothing further.
Anything further?
I have nothing further.
All right. May Mr. Sasser be excused with the usual admonition?
No objection, Your Honor.
No. I mean, yes, Your Honor.
Your Honor, if I might, I would move that defendants R, S, and T be received into evidence.
All right. They will be received. Mr. Sasser, you are not released from your subpoena, however. You can be called back on at least 24-hour notice, hopefully if it's necessary to come back. All right. Let's take a recess at this time. All right, we are back in session. Let the record show that parties and counsel are all present. The case is with the people. You may proceed, Mr. Plummer.
Thank you, Your Honor. The people called Charles Craig.
You will be seated, Mr. Craig, please, and state your name and spell your last name.
Charles Eugene Craig, C-R-A-I-G.
Thank you. Counselor, you may proceed.
Thank you, Your Honor. Mr. Craig, what is your occupation?
I'm a police officer, sergeant with the Wairika Police Department.
And how long have you been employed in that capacity?
Over 6 years.
Were you employed in that capacity on the 16th and 17th of July, 1988?
Yes, I was.
Were you on duty? Did you begin on the 16th of July on that date?
Yes, I did.
All right. Directing your attention to sometime around midnight or shortly thereafter, did you find yourself in the vicinity of the Sports and Spirits liquor store in the city of Wairika?
Yes, I did.
Did anything occur at that time which attracted your attention?
Yes, I saw John Thurman run to the 76 station.
Did you recognize John Thurman at the time that you saw him?
Yes, I did.
How did you recognize him?
I've seen him before as a clerk at Sports and Spirits.
You indicated you saw him running.
Yes, I did.
What time or what did you do when you made that observation?
Well, I pulled in the 76 station to see what was going on into that area of the lot.
Did Mr. Thurman do anything that attracted your attention at that time?
He yelled to some of the people at the Sports and Spirits to call the cops.
Okay, I'm going to stop the recording and then restart it, and I'll be starting up again with a, actually, I probably have some warm up from this take, so I'm not going to stop it just yet. Sorry. Let's see. Take one, pass them down. So we have. We have a little bit of warm up. We'll do this so we can get this on the same segment of the recording. I am plaintiff attorney, Mr. Lunsford.
I am the witness.
I am the court.
I am attorney for defense, Ms. Nguyen.
Just a minute, and let's make sure I stop at the right place. Okay, so we're gonna go to page 4, line 21. We're gonna stop, warm up. Let's keep it in 14s. Okay, beginning with question by Mr. Lunsford on the record. Page 1. Does Mr. Thompson appear to be the same height and size as when you were robbed?
He's taller than me and beefier, yes.
Had you ever seen Mr. Thompson before that day?
I don't ever recall him being in the store before.
Back then, on November 15th, you said you had worked there for about 5 years?
Yes.
Were there any other clerks that worked with you back then?
There were several clerks that worked with me, but at that time, there was only me in the store.
Okay, I have a CD that I've already put into the laptop, Your Honor. If I can mark the CD as People's 3, I'd like to play it and have the witness describe what we are looking at.
All right. Can everybody at that end see? Proceed, counsel.
Do you recognize what's shown on the video screen right now, ma'am?
Yes, that's me behind the counter at the store.
Okay, now first of all, is this the video store we're talking about, video 88?
That's most of the store, yeah.
Okay, where would the front door be?
The front door is way towards the end of the counter, back there.
And where are you in this picture? First of all, are you shown in this picture?
Yes, I am.
Where are you?
I'm behind the counter next to the computer.
This would be you?
Yes.
And do you recognize who this person is?
That was the robber.
Okay. Is this how the counter looked that day?
It did.
I'm going to play more. Now, ma'am, in this sequence of pictures that you've just seen, what is this that is occurring at the counter here?
It's hard to tell. I don't think it is as soon as he walked in because the Pepsi is already on the counter.
Okay.
This is when I guess he already started touching the empty movie cases, putting them on the counter.
Where on the counter would he have been putting them?
Towards the end on this side,
Are you talking about down in here?
in that area.
And the Pepsi, you said the Pepsi is already on the counter?
Yes.
Where would the Pepsi be?
The Pepsi would be between the two computers in the middle.
Here?
Yes.
Do you see the part where the man was reaching over and taking the money out of the register here?
Not yet. The register is actually behind the second computer.
Which computer would that be?
The one in the middle.
Here?
Yes.
So this is the spot where Mr. Thompson did the robbery.
That is where he reached over and grabbed the money. The robbery began where I was standing. I had to walk over from that computer to the next one
Why?
because he was threatening me.
I'm sorry. Do you have money under this computer?
No,
Is the only place where you have money in the store under this computer?
that one and the last computer.
Down there? Did you ever go down to this place?
No, I never touched that one.
And does this appear to be pretty much how Mr. Thompson looked that day on November 15th?
Yeah.
I'm going to show you a series of still photographs, ma'am. I'm going to mark them People's 4, 5, and 6. Here is People's 4. Do those two pictures appear to show still photographs of what you were seeing in the slideshow or in the pictures that we were showing on the video screen?
It looks like it.
Okay, that was 210. Warm up from what will now be a test, which I'm going to put on a different recording. So don't go away. I'll be right back.